Hi, thank you for taking the time to review this recorded webinar on the Seattle Domestic Workers Ordinance. This webinar was created by the Seattle Office of Labor Standards. My name is Jennifer Molina, and I will be serving as your facilitator. During our time together, I will share with you information regarding the Seattle Office of Labor Standards and give you a quick overview of the Seattle Domestic Workers Ordinance, which took effect July of 2019. Before we dive into the ordinance, I'm going to share with you some information about the history of labor standards in Seattle. The City of Seattle passed its first labor standard in 2011. And between 2011 and 2015, the City of Seattle passed a total of 4 ordinances. In 2015, the Office of Labor Standards was created to enforce and implement all of these ordinances. The mission of our office is grounded in workplace equity. As of 2021, the Office of Labor Standards oversees a total of 16 labor standards. The Office of Labor Standards, also known as OLS, offers information to workers about their rights under Seattle labor standards. Our services are free and private, and we also provide interpretation and translation services for those who need them. Our enforcement team investigates hiring entities after a worker reports a violation. But of course, we hope that through compliance assistance and trainings, we can prevent that from happening. We always encourage workers to reach out to us with questions and highly encourage employers to connect with us and together make sure they're in compliance. The Seattle Domestic Workers Ordinance came from community organizing, just like all of our other ordinances. It gives basic workplace protections to domestic workers. It also requires establishing a Domestic Workers Standards Board that will make recommendations for future policy changes. It is important to mention that this webinar is for informational purposes only and is not for the purpose of providing legal advice, creating an agency decision, or establishing an attorney-client relationship between the Office of Labor Standards and the recipient. Any responses to specific questions are based on the facts as we understand them and are not intended to apply to any other situations. If you need legal advice, please consult an attorney. Not a lot of people know this, but Seattle was the first city in the United States to have a Domestic Workers Bill of Rights. According to the Seattle Domestic Workers Alliance, there are approximately 33,000 domestic workers in the Seattle area who will benefit from this ordinance. OLS has partnered with community organizations to disseminate information and together make sure domestic workers know about their rights and hiring entities are aware of their obligations. This ordinance applies to individuals, households, and companies who directly hire or employ domestic workers in the Seattle area. If you live in Seattle and you have work done in or around a home by a nanny, cook, home care worker, house cleaner, household manager, or a gardener, your home is someone else's place of work and you are considered a hiring entity. As a hiring entity, you must provide domestic workers with payment of Seattle's minimum wage, uninterrupted meal and rest breaks, or extra pay if they don't get a break, 1 day off, and we're talking 24 hours, after working 6 consecutive days. And this is for workers who live or sleep where they're employed. The right to retain documents and personal effects, and protections against sexual harassment and discrimination. Every year, Seattle's minimum wage increases on January 1st. Recently, OLS announced the 2021 minimum wage increase, which will be $16.69 an hour. For more information on the minimum wage ordinance and how it applies to you, please contact us directly and we will answer all of your questions. Under the Seattle Domestic Workers Ordinance, domestic workers have the right to receive a meal period of 30 minutes for every 5 hours worked and a 10-minute rest break for every 4 hours worked. Rest breaks are always paid and meal periods may be unpaid depending on the circumstances. A rest break is 10 minutes of uninterrupted time when a domestic worker is completely relieved from work obligations. As with meal periods, this means the worker is entitled to choose how they spend their time and must not be required to engage in anything related to a work task. The hiring entity may not surveil or monitor a worker during their rest break. A domestic worker who resides or sleeps at a place of employment cannot be required to work more than 6 consecutive days for the same hiring entity without an unpaid 24-hour period of consecutive rest. For purposes of determining 6 consecutive workdays, any amount of work in a 24-hour period qualifies as a day of work. A 24-hour period of consecutive rest means that the worker is completely relieved from work obligations and not required to remain on site or required to return to work if called. Hiring entities are prohibited from keeping the personal documents of a domestic worker or other personal effects, like a visa, passport, work permit, their money. It is important to mention that domestic workers have the right to protections against discrimination and retaliation. Hiring entities are prohibited from taking an adverse action or discriminating against domestic workers who, in good faith, assert the rights established by this ordinance. These rights include, but are not limited to, engaging in the protections afforded by the ordinance, such as taking a meal period, rest break, or day of rest, asking questions about the rights under the ordinance, filing a complaint about alleged violations, and participating in an investigation of alleged violations. Hiring entities are subject to penalties if they take action against a domestic worker for asserting their rights or filing a complaint with the city. To learn more about how domestic workers are protected from retaliation for asserting their rights established by the ordinance, such as requesting the right minimum compensation, paid rest and meal breaks, or retentions of their personal documents, please contact the Seattle Office of Labor Standards. To learn more about how a domestic worker is protected from discrimination and harassment, please contact the Seattle Office for Civil Rights. The City of Seattle is here to help hiring entities understand their obligations under the Domestic Workers Ordinance and all other labor standards. All of the rights we just went over cover both employees and independent contractors. Once again, nannies, home care workers, house cleaners, cooks, household managers, and gardeners are protected under the Seattle Domestic Workers Ordinance, regardless of whether they are hourly or salary employees, independent contractors, full-time, part-time, or temporary workers. However, individuals who work on casual basis, individuals in a family relationship with the hiring entity, or home care workers paid through public funds are not covered under the Seattle Domestic Workers Ordinance. Our time together has come to an end. To learn more, you can visit our website. Under the Domestic Workers Ordinance section, you will find a comprehensive Q&A along with other useful materials. Or better yet, give us a call on 206-256-5297. You can also email us at laborstandards@seattle.gov. We will be more than happy to answer all of your questions to the best of our ability. The OLS Outreach and Education team is also available for one-on-one trainings that will provide you with a deep dive into the ordinance. At the City of Seattle, we want to make sure hiring entities understand their responsibilities under this and all other labor standards. On behalf of the Seattle Office of Labor Standards, thank you for your time and enjoy the rest of your day.